C is now in session.
Thank you, Madam Clerk, and good afternoon to the attorneys. Welcome to the Tennessee Court of Appeals. Your panel today consists of Judge Frison, Judge Davis, and myself, Judge McClarty. You probably already know this, but if there is any technical matters that develop, please let us know immediately so they can be addressed. Also, you will be presenting your case as if you were actually in court, except you will not need to rise. You may be seated as you make your presentation. I assume that I think that the appellant has already reserved the rebuttal time. Is that correct?
That's correct.
Okay. Madam Clerk, are there any preliminary matters we need to take care of?
No, Your Honor.
In that case, will you please call the first case?
In re Conservatorship of John F. Ress.
For the appellant, you may present your argument.
Good afternoon. I'm Jason Creech of the Washington County Bar. And as I was preparing for this oral argument, I had a little bit of deja vu in the sense that I was just before this Court of Appeals 6 months ago on an oral argument on a case that involved the exact same issue, the exact same situation, where marital dissolution agreement was interpreted using inappropriately parole evidence. And I believe the law now is the same as it was then. And that was from the Lockett and Runyon case, which I've cited in my brief. A very brief summation of the law that's important to hear is that these marital dissolution agreements are contracts and they're enforced as any other contract. And the critical juncture is that we don't consider anything that occurs before a fully formed and incorporated marital dissolution agreement, except for when there is an ambiguity in the document itself using its plain and clear language. And that ambiguity has to mean that a phrase can be interpreted one of two different ways, in which case parole evidence may be used to clarify but not contradict the contract. And unfortunately, we have reversible error here because that's exactly what this trial court has done. It's used parole evidence to contradict and invalidate a fully formed contract. The case has a little bit of unusual facts in the sense that the husband, Mr. Ress, I believe he had dementia, was not able to manage his affairs, and a conservator was appointed for him. And there's a significant gap of time between the complaint for divorce in 2014, when the mediation was held in June of 2018. There was a mediation held, and it was an informal handwritten agreement that was reached. That was never intended to be the final alliteration of the parties' agreement. The MDA itself was executed in August 2018. And I want to draw the court's attention to two provisions, because this is really where I think the case lies. Paragraph 10 of the MDA had a clause, and it's a contingency clause. It actually is not relevant or germane to the equitable distribution of assets and debts, because it is an estate planning vehicle that was specifically negotiated in the MDA. If you'll look, it says, as a contingency, if Mr. Ress dies before Miss Ress, then all of his remaining assets will revert to wife. So again, with the contingency, Miss Ress could have died first. This could have never happened. It was contemplated that the division of assets will have already occurred. And this was an estate planning vehicle because if you read further, his conservator had the additional obligation of drafting estate planning documents that were necessary to carry out the terms of the agreement, which of course were never done. And the next provision is paragraph 11L, which specifically says this marital dissolution agreement supersedes any and all prior agreements. That is to say, anything that may have been written, agreed, signed before is of no effect. This is the agreement. So fast forward in time, unfortunately, Mr. Ress did pass away. And after a period of time to allow for grieving and a respectful period of time that I would say, we made requests that this contract be carried out. It wasn't. We filed our motion to enforce along with a motion in limine because we were getting very direct signals from the conservator that she was going to be relying or attempting to rely on this old handwritten agreement that she said provides some other agreement. At the hearing in front of the court took no proof whatsoever, only argument of counsel, instructed us to submit our briefs, or I'm sorry, memorandums of law, which we did. And next thing I know, I get an order back from the court that completely eviscerates the parties' agreement. And I believe the wording of the order itself from the trial court establishes the reversible error. If you look at paragraph 1 of the court's order, it says a latent ambiguity exists not in the marital dissolution agreement. It says a latent ambiguity exists between the mediated agreement and the marital dissolution agreement. The parole evidence rule says you have to have the horse before you get to the cart. In so many words, the court should have found, if it was going to look at parole evidence, it has to first find that there's an ambiguity in the wording of the NDA itself. It didn't do that. It started with looking at all of the documents at the same time and saying, well, there's some differences here, and I don't like the result, in essence. In fact, in paragraph 2 and 3, the court talks about the wife's interpretation of the contract would have this result. The conservator's interpretation would get this result. And I think one is more equitable than the other. And again, I don't think that's an avenue the court had the ability to go down, because the MDA was fully formed and incorporated, and the parties determined what was an equitable distribution of the assets and the debts of the marriage. And again, this was a separate estate planning vehicle. This is no different, really, in my mind, than when you have a marital dissolution agreement and John Doe is paying alimony to Jane Doe, and Jane Doe says, I want in the agreement you to carry me as a beneficiary on your insurance policy. That's a negotiated provision we make all the time. It's not an asset that exists at the time, but it is something that can be contracted for, which is what the parties did. So this is not a minor thing that was slipped in the final drafting of a document. This was a very important provision that was signed by everybody. The second issue of deja vu is that I was before this court in 2018 in the case Miller versus Miller, where this very same chancellor made a ruling that was in my client's favor. And I was trying to defend that order of the trial court. And this court gave me a very hard time in oral argument because there was no actual proof taken. There was statement of counsel, there was a document presented to the court, and this same chancellor made a ruling, again, was in my client's favor, but this court gave us an unfavorable decision because you said, no, there has to actually be some proof here. There has to be some evidence. And that's the problem that we have here. The court heard everything on a video monitor because it was all remote court and simply went back in chambers and came out with a decision. So the second item of reversible error is I don't think you can just decide that there's some kind of ambiguity when there's no actual proof that any of the parties had anything other but the same agreement in the marital dissolution agreement. This agreement is also not ambiguous in practice because if you look at the conservatorship side of the case, the conservator filed a final settlement and accounting and was able to reduce, quote, all remaining assets of the ward. In fact, if you look in the record, the actual all remaining assets equates to $140,000. I'm sorry, $339.03. We were literally able to, down to the penny, determine what was the, quote, remaining assets of the ward from the contract. So the real gist here is that the conservator signed an agreement, but when it's time to settle up and do what the contract says, and she realizes this contingency has happened, she does not like it, does not want it to occur. And under our laws, that's just simply not sufficient. And the trial court should be reversed and remanded for execution of your. And with that, I'll turn it to my adversary.
Thank you. You do have your rebuttal. Yes, sir. You prepared for your presentation.
Good afternoon, Your Honors. May it please the court. I'm Lee McVeigh from the Sullivan County Bar, representing Judith Williamson, the conservator for John Ress. A lot of my argument is going to be centered around the question of why. And I believe if you look at the documents, there are going to be several questions of why that create that ambiguity that the court has to resolve using the mediated agreement. That when I reference the mediated agreement, I mean the handwritten agreement the parties entered into after mediation. It's not, I want to be clear, it's not that we are not saying that the marital dissolution agreement is not a contract that has to be enforced. What we're saying is there is an ambiguity within that marital dissolution agreement that has to be resolved using parole evidence. And the best evidence, regarding the argument that there was no evidence taken in court, the best evidence of what that, how to resolve that ambiguity is to go back to this handwritten agreement that the parties entered into literally minutes after they actually had an agreement.
Mr. McVeigh, what specifically do you say is ambiguous in the MDA?
So in the marital dissolution agreement, you will notice on in paragraph 10, the estate claim, there's a handwritten interlineation of Mr. Ress's attorney, John Parker. John Parker hand wrote remaining in the into the draft. Mrs. Ress's counsel drafted this marital dissolution agreement. Mr. Parker looked at it and hand wrote remaining and initialed it in paragraph 10 of the marital dissolution agreement. Now, it already said that the conservator shall transfer all of husband's assets to wife. If there's a reason that Mr. Parker put remaining in there, why that is, that's one of the whys, Your Honor, is why if all means all, and by definition, if this paragraph goes into effect, Mr. Ress is dead, and so his remaining assets are all of his assets, and so if all means all, then why would Mr. Parker feel compelled to handwrite remaining in this paragraph? Now we can guess at that. I would argue on our side the reason that he did that is he wanted to make sure, because this paragraph does give the wife a claim against the estate. He wanted to make sure that the wife couldn't claim the entire $250,000 that had been transferred over to Mr. Ress by Quadro. I would submit that's why he did it. Obviously, we don't know why he did it, but there's no.
What's ambiguous about all remaining assets? I mean, I get your argument. Why did he put remaining in there? All means all. I mean, if anything, remaining is superfluous, but it doesn't make it ambiguous. All remaining assets means everything you've got left.
I agree, and I think even in our brief, I said if that had been typed in, I think it's more than just the language; it's the actual action of handwriting that in that creates the ambiguity. If it had been typed in originally, I think the argument is much different because there's no effort to clarify remaining assets. But I would agree with the assertion that, hey, if this had just said all remaining assets, but the issue is there was a purpose in doing that that we don't know the reason. We don't know why that was put in there.
And we still don't know why either, because the judge didn't take any evidence on that, did he?
Well, he didn't, and Mr. Parker's passed away, so I'm not sure what other evidence. Yeah, I'm not sure other than, again, going back to this handwritten mediated agreement everybody signed, I'm not sure what other evidence we could actually take that would help explain that. But you're correct. There was no evidence taken, and we don't really know why. If we go back, and there's also the issue of the final decree of divorce. The case law is clear that the court's order, this court has to construe and use the construction rules with a court's order the same as it is with a contract. And so if you go look at the actual final decree of divorce, it references multiple different documents. So it references a mediated marital dissolution agreement and just what I will, in country terms, call a plain old marital dissolution agreement. And that would seem to be a distinction without a difference, except if you look at the way the court uses it. It's on the signature page in the third paragraph from the bottom. The court says it is further ordered and adjudged that the mediated marital dissolution agreement executed by the parties is approved. And then the very next paragraph, it says it is ordered and adjudged that the conservator, Judith M. Williamson, has the authority to execute all provisions of the marital dissolution agreement. And so one of these documents, it would be easy to skim over it and say, oh, well, the mediated marital dissolution agreement and the marital dissolution agreement are the same thing. But the court references it in its decree in two different capacities. It references one document that's been executed by the parties, and it references another document that the conservator has the authority to execute in that document. And so, again, that creates another one of these questions: why? Why would we reference two different documents? Why would the court give the conservator the authority to execute one and then approve one that's, as the court says, been signed by all the parties? And so if we're construing this final decree of divorce and we're trying to, and we use the same rules of construction that we use in a contract, then I would submit that also creates an ambiguity that needs to be resolved. And again, the best evidence to resolve that is the handwritten mediation agreement that the parties entered into right after they had their agreement. The other factor is that if we look at intent, I mean, one of the things that we also have to do is look at the parties' intent, and all the parties, including the court, have the obligation and have to have the intent. I mean, I think we have to have the intent to follow the law, that a distribution be equitable. And while I know that there are paragraphs in the marital dissolution agreement that say where the parties agree this is an equitable distribution, that really goes back to how the parties interpret the marital dissolution agreement. If Mr. Rest, through his attorney, believed that by inserting the word remaining into the marital dissolution agreement, they accomplished what they thought they accomplished in the handwritten mediated agreement, then they thought it was equitable. And that was, I mean, I don't think there's any disagreement by any party that what the parties achieved in their handwritten agreement was equitable. And I don't think it's out of line or unreasonable for Mrs. Williamson, as a conservator of Mr. Rest, to consider that agreement equitable, assuming, and then of course this is where the rubber meets the road, assuming that inserting the word remaining accomplished what they thought that it accomplished. And so that goes back to the question that we were just addressing earlier: is why would we put remaining in there? What is the purpose of handwriting remaining in there? If again, all means all. And as I stated, the answer to the whys that have come up both through the final decree of divorce and the marital dissolution agreement, the best evidence of those answers, of the answer to those whys, is in that mediated agreement. The handwritten mediated agreement is unambiguous. It's very clear on what the parties' obligations were. And it's not been argued otherwise. The appellant doesn't come in and say, no, this marital dissolution agreement, this is what we anticipated, this is what we thought was going to happen in the mediated agreement. The appellant says, no, let's ignore the handwritten mediated agreement and go with the marital dissolution agreement. That just, again, with the ambiguities that are there, with the rules of construction, what they are, I believe that the trial court was correct when it found an ambiguity. I believe it was correct when it resolved that ambiguity using the parties' handwritten agreement that they signed minutes after they reached their agreement. And I think this court should uphold that finding.
Did the trial court actually find an ambiguity, or did it declare an ambiguity? If it found an ambiguity, explain to us what is that ambiguity it found. How it come back from that?
Your Honor, I suppose it more declared an ambiguity. It was the trial court was not specific in the ambiguity it found, other than saying it found an ambiguity between the documents. It did not specifically state, other than the argument about the equitable outcomes. And that was, one of the things that we argued in a memorandum of law is the equity required in the original final decree of divorce. But as far as a specific,
is an equity something in a divorce, something that should be resolved at the beginning, at the time the parties did their divorce? Shouldn't that have been either declared by the court at that point or appealed if someone felt that it was inequitable?
Well, Your Honor, I believe that hits right.
Can we go back now and look at that divorce, how many ever years it was in the past, and not considering the divorce itself, but considering the actions of the parties, what they have already proclaimed? Can we look at that agreement and say that's inequitable?
Well, I think, Your Honor, that gets to the actual ambiguity of this agreement. It's not that we want the court to go back and decide whether it's equitable now. What we're saying is it was, under our interpretation and the way that we feel the ambiguity should be resolved, it was equitable at the time. Because at the time, the way we saw it, the only thing that was going to go back to Mrs. Ress was whatever was left from the money transferred at the Quadro. And so it's not a matter of looking at what's happened now and saying, is this equitable? It's saying, no, it's saying, yes, it was equitable at the time. And because this is the way we're going to construe it at the time, it's equitable. We're not asking the court to try to determine now what's equitable. We're saying that at the time, under our interpretation, under how we think the ambiguity should be resolved, it is equitable, and it was equitable when we signed it.
What do you do with the language in the MDA that says including but not limited to the Quadro?
Your Honor, I think that also creates an ambiguity because, the included but not limited to language, which is in a way boilerplate language. Almost, if you look at that and then you say, okay, the funds received by Quadro. Well, if they meant all, why did they even reference the funds received in the Quadro? And so,
because they meant every darn thing.
Well, and I understand understand that position, but if they meant every darn thing, then they don't even need to put in the funds received by the Quadro. They can just say all, and all means all. But what we've done is we've taken all, and then we've added remaining, and we've said also the Quadro. And I think the including but not limited to language, I understand that position of saying, hey, they put that in there, that means all. But then we say funds received by the Quadro in paragraph 5B. Almost, again, do we mean all, or do we mean the funds received by the Quadro? And then we have Mr. Parker handwriting remaining in there. It just, again, at the end of the day, all of that language together creates an ambiguity that is again very easy to resolve using the handwritten mediated agreement. And I was finished with my argument. If there's any other questions, I know I don't have but 10 seconds left.
I hear none. Thank you very much, sir. Yes, sir, you have your rebuttal.
Thank you. I would probably summarize the opposition to our appeal as a series of very entertaining red herrings. I don't think any of these points are persuasive because, to Judge Davis's point, their interpretation doesn't resolve a conflict. It creates a conflict because it totally would invalidate the phrase including but not limited to. And it would totally invalidate the requirement in that provision that there be estate planning documents drafted to carry out the terms of the agreement. And it would also invalidate the portion that sets off a separate paragraph of the quadro. What I mean by that is the retirement assets that are required to be transferred by a qualified domestic relations order were segregated in the agreement to paragraph 5B. And obviously, the transfer of retirement assets are a little more complicated than your average transfer of a bank account, so to speak. But it segregated that transfer to 5B. And again, the including but not limited to indicated not only the assets from paragraph 5B are to go back to the wife, but all remaining assets. So as to why, I would propose to the court, it does not matter why. The agreement speaks for itself. I would say, though, that the why it remaining was put in there is because Mr. Ress was in a position where his assets were going to be given to him, and then they're going to be immediately spent down for his care, given his physical and mental health. If you look on the conservatorship side of this case, the conservator filed a statement of all of his money in the world. As of April 2019, he had $168,969. If you fast forward to May 2020, it is now the 140,000 and change. And that's because it took his assets being spent down for his care. So the remaining, while I agree it may be superfluous, I think you have to understand it in context, and that the assets that were given to him were going to be depleted over time. And nobody knew how long he was going to live at the time the agreement was signed, which is why if Mr. McVeigh wants a why, that is why. It's because those assets were going to be spent down, and you couldn't pinpoint at the time of the agreement what that number would be, because it's based on a contingency that may or may not happen, or may happen who knows when in the future. As to the final decree saying the mediated marital dissolution agreement, the marital dissolution agreement, at best, that's a Scrivener's error, because it always speaks to the singular agreement. And again, to take their proposition to its logical conclusion, it would invalidate the final, it would invalidate the marital dissolution agreement, paragraph 11, where it says this agreement supersedes all others. So it's a logical fallacy to go down this rabbit hole of saying the final decree says the mediated marital dissolution agreement versus the marital dissolution agreement. When the parties have spoken through the language of the agreement and said there is only one agreement, which is the agreement the court adopted. Because if you look in the file, when the final decree is entered, the only filed agreement is the marital dissolution agreement. This handwritten document never appears in the record until about May 19, 2020, the same day the conservator is filing the final accounting. We don't ever hear of this document until she finals out the assets and debts of the ward. And again, the concept of equitable, I agree with this court, that distribution was equitable. The parties made an equitable distribution. The court said it was an equitable distribution. What we're talking about now is an estate planning provision, not a division of assets pursuant to a divorce, but a contract for what may happen to each party's assets years down the road or not at all, depending on how the contingency played out. And so that's my case, and I ask your honors to overrule the trial court and carry out the marital dissolution agreement as written.
Thank you very much. We're going to thank the parties for your presentation to the court. Your case has now been submitted to this court. You will receive an opinion from this panel within a reasonable period of time. Thank you very much. If there's nothing further, then the attorneys may be excused. Ms. Clerk, will you kindly recess court or adjourn, recess to our next docket?
Yes, sir. The Honorable Court of Appeals of Tennessee